Good morning.
Good morning, sir.
Good morning, Ms. Abdul Nabi. Good morning, Mr. Shamsi.
Hi, good morning, sir.
Good morning.
Good morning, Judge Ali. I would like to begin by reading out the statement.
Please, have you started the recording here?
Yes, it's started.
Go on, please.
The hearing is in the matter of CFI-055 before His Excellency Justice Ali Madhani and is being held by way of video conference. Any orders or directions made after or during the course of this application will be issued by the Registry in Dubai on His Excellency Justice Ali Madhani's instructions. The claimant is represented by Clyde & Co. Lead counsel is Sophia Hurst. The defendant is represented by Zaid al-Shamsi Advocates and Legal Consultants. Counsel is Zaid al-Shamsi.
Well, good morning again, everyone. We're supposed to hear today the application for a set-aside application. Unfortunately, last night I have received an alert from the registry that Shamsi office has applied for adjournment of this hearing for another date so they can appoint another counsel. So we would hear from Mr. Zaid Shamsi, that's how we're going to deal with this matter. Mr. Zaid?
Yes, sir. We request you to postpone the hearing just 2 weeks. They will join us, Baker McKenzie office, and they have more experience in the DFC system, and we want to serve our case good. That's we ask them to join us. And we request the court to give us 2 weeks more, please.
I see. Well, usually, Mrs. Shamsi, what you usually do before this court, if you have any application, if you have any request, the first things to do is that you write to the opponent, to the other party. If you could agree with the other party, the court would agree almost automatically with you. So, and this is for your future dealing with the DIFC court. Whatever you want to do, you write to other party and tell them, "Wait, we have an issue. We want to do this. How about?" But you need to bring it like not the night before the hearing, a couple of days ago. You need to tell them because all parties registered with the DIFC court have a duty to collaborate with each other, to help each other, to assist each other, because one day you will need adjournment, the other day they will need adjournment. So that's why the lawyers are working on a more corporate basis. But you can't take your opponent by surprise. You can't come in the morning and say, "Well, I want adjournment," because the court would be very busy. It would be maybe impossible sometimes to adjourn for 2 weeks. But so before I decide in this matter of adjournment, I want to hear from the claimant. Yes.
Judge, good morning. Ms. Hurst here. Can you hear me and see me?
Yes, Mr. Hertz, I do hear you and I do see you.
Great, I'm grateful. We do resist this application to adjourn. As you've already identified, this was made very much at the 11th hour, and it was not notified to us in advance. It was not even served on us. We were only made aware of the application because we happened to be checking the e-portal. So this is truly at the 11th hour. And unfortunately, we do say it is symptomatic of the way that the defendant has approached this application. It is their application. Skeleton arguments were due last Wednesday. Counsel asked for more time to file their skeleton arguments. And we say there's no reason why this problem, as to the defendant's representation, could not have been identified at a much earlier stage. Present representation has been involved throughout since this application being served, since the claim, I beg your pardon, being served in August. So if there was a difficulty in understanding the nature of the claim or in dealing with the DIFC, then in our submission that could have been identified at a much, much earlier stage. I do also emphasise that this is an application to set aside a default judgment on what are, in my submission, very simple facts. it's a loan that has not been paid. That is the essence of the claim that's made. We do say that it's relevant that the defendant appears to defend that claim on the basis that he has no funds to pay, but now proposes to instruct Baker McKenzie. And I mean no disrespect to either party when I say that is, in my submission, a Rolls-Royce option. And the court can have some scepticism as to whether this change of representation is simply another tactic to delay. As I say, Judge, this is an application against my client, but we do want it dealt with promptly, and we're entitled to have it dealt with promptly. My client currently has the benefit of a judgment, a regular judgment, entered by this court in accordance with its rules, and absent this application and a stay of enforcement of that judgment, it would be entitled to enforce in respect of loan monies that have been outstanding for over a year. We do want this application dealt with promptly. And I also submit that the defendant ought to want to have this dealt with promptly. And I say that because, as the court will be aware, one of the considerations for your lordship in determining whether he should have the judgment set aside is whether he has acted promptly and reasonably in bringing his application before the court. That is a relevant factor to the test. And I do put down a marker that whatever you decide on adjournment, I will rely on this latest example of delay in my submission that he has not acted promptly and judiciously, and that should be a factor against any relief on the underlying application. So that is the claimant's position.
Well, Ms. Hurt, I don't know, in my account, in my records, with the defendant, once they were served with the default judgment, I thought they really have dashed into the court. They have applied for a set-aside application. I don't know, in your assessment, whether that will be a prompt response or not, but we do have a response. We do have a defense now to this claim. We do have a defense that accounts against some payments towards the claimant. We do have some other facts pleaded by the defendant, although not in the ideal way. So we would understand this as a civil law firms, trying to defend as a client before a common law court. We see, if you go to the overriding objectives and the duty of this court is that to keep parties in equal footing and to serve justice at the best way for both parties' benefit. We're understanding you already have a judgment in your favor. This application is not intervening maybe with your judgment yet. There are so many options, Ms. Hurt, in dealing with. First option is that this court can just jeopardize this hearing and deal with the application on paper. So the court could deal with it because we already have the submission of the defendant before us. I might ignore the application for adjournment, and it depends on Mr. Shamsi's consent. That's one of the things this court could deal with it in paper. So we didn't need a. You might submit from your side. They don't want to submit from their side. This is one of the things. And the other thing is that I do not really initially. I'm not giving this, Ms. Hurt. But this is something I've been thinking about this morning. A 2 weeks time for a Part 1 registered practitioner to ask for hearing, for him to be allowed to represent his case fairly by an admitted barrister or admitted lawyer, isn't asking for too much. What you want to say now, Ms. Hurt?
Well, my lord, simply that we are all here now, and my client has been put to significant cost already in preparing for this hearing. If your lordship is minded to adjourn, then we would be asking for all of the costs which have been thrown away by the parties turning up, preparing and attending this hearing. And any hearing that your lordship does adjourn, we would ask for that to be brought on at the earliest possible date so that this matter can be dealt with promptly.
I see. Okay, this is you just giving me a light toward the end of the tunnel. So we usually do that if one party's cause delay or cause the other party a certain and extra burden in the preparation of this case. Sure, the cost would be added into that. But I would turn now to Mr. Shamsi and I would see, I would ask him if they would be willing to accept you're appearing for this. What is it? See, one more thing, Ms. Hurt, is that your preparation to defend the application would be count either today or the next hearing. So that's one thing. And that would be decided depend whether the defendant would be successful in bringing the default judgment into the grounds or not. If it's not, you be awarded your cost in full. If they won, the cost will be on your side. But there is one thing what we can do today. I said with the condition that Mr. Shamsi's agreement, your appearance for today's hearing cost would be reserved to your side. If Mr. Shamsi agree to reserve the cost of you appearing before this court for this couple of minutes for today, then does that mean you agree to postpone for a very short notice hearing? Ms. Hurt?
Well, my lord, simply this is very prejudicial to my clients. We have, it's their application. We haven't moved the court. We have a judgment. The defendant has made an application and is now taking every step not to pursue that application. It does cause my client significant prejudice to have expended the time and cost in preparing our response to that application promptly. They have had ample time. This application was made in September. We've been preparing since that date. Skeleton arguments were due a week ago. There is absolutely no reason why this problem could not have been identified at a much, much earlier stage. If there has been a problem with the defendant's representation, why was that not notified to the court? Why was that not notified to me and to my clients? At the very, very latest, last Thursday, when skeleton arguments were due to be exchanged. It was not raised with us. There was no dialogue. We could have had a discussion. We could have looked at dates. We could have thought about agreeing to an adjournment. But the position is this: we are here. My client has incurred significant fees in preparing this case, and we are all here ready to hear the application. That is a prejudice that's caused to my client. And we would respectfully ask for it to be dealt with today. That is my primary position. If you're not with me on that, then I do say that we are entitled to all of the costs that have been thrown away, as we will have to spend yet more costs to turn up to an adjourned hearing. But as I say, in my submission, there is no reason why your lordship could not continue in the remaining time that we have available, ample time in my submission to deal with this application today.
Well, I see your point. Mr. Shamsi, what do you want to say about this?
Actually, we face a little bit difficult to contact the another party because there's inside issue. There is a consultant should be present our firm in this case, but he have excuse in the last minute. That's we are have a problem to contact or have time to submit the request to the court or the another client.
Well, Mr. Shamsi, would you agree that for Mr. Hurt, cost for today appearing before this court would be reserved in her favor, whatever the conclusion of both of the matter at the end, in favor of granting you this short adjournment application?
I didn't hear you, sir. Again, please.
I said, do you agree that this court grants Ms. Hurt the cost of today's hearing in favor of granting you the adjournment application? Her cost for today.
Yes, sir.
You agree to that?
Yes.
Well, Ms. Hurt, I mean, having a part one, appearing before me and not allowed to pursue a hearing before a CFI court level will be a very difficult things to do. We would need to look at the parties' interest, the lawyer misconduct whatsoever. Well, in my assessment, Mr. Hurt, I'm really in favor of adjourning this case for about 2 weeks, something like that. And yes, your cost will be preserved to your favor. This is, I'll call it a wasted case. And then it's recorded, so it will be in your favor. All other costs will be dealt with later, according to conclusion of every single application. And I would really love, I'm urging you to collaborate with Mr. Shamsi and to fix a next hearing trial within the week that's commencing. I would say, if you bear with me for a minute. Sixth of December, 6, 7, 8, 9, or 10. And if you can agree in one of these dates, this is my favorite because I'll be week off before this week, and I'll be 2 weeks off after that week as well. So this is the only week I'm available, and fortunately I am free in the whole days of that week.
Judge, we will of course liaise as to dates. Can I clarify the terms of your order on costs?
Yes.
I do request that those costs, rather than being reserved, will be payable immediately. We have filed a schedule of costs, and in my submission there's no reason why those can't be assessed and be payable immediately. I say that because the defendant has undertaken a similar tactic in proceedings in the UK, where he's also adjourned various hearings, applications at his own instigation, and we are being put in a prejudicial position by having to turn up to court again at cost risk to my client, bearing in mind, my lord, that there is a judgment outstanding for monies over $1 million that hasn't been paid to my client. So we are incurring more and more cost. I do request that those costs be payable today.
Well, Ms. Hurt, I think that is a difficult application you're making now. We know that your judgment is subject of a set-aside application. This is issued to be decided. Your bill of costs is, I'm seeing that it's detailed, and I cannot now decide it for you as a winning party for now. As I said before, even in case you lose your case and set aside, today's cost will be preserved in your favor. This is the only decision I can give you for now. All other costs would be reserved to be dealt with toward the end of hearing that application. Is that clear?
Judge, yes.
Yes. So, Mr. Shamsi, so we will grant you, we agree to adjourn this case to be heard in the week commenced 6th of December. You with me? Do you hear me clearly?
Yes, sir.
Any day in that week, if you agree with Mr. Hurt, a specific date that's suitable for you, and that will be your last chance. The cost of today's hearing only reserved in favor of Ms. Hurt's appearance. The rest of the cost will be decided accordingly with the outcome of the set-aside application. Are we clear? Do you have any other questions, Mr. Shamsi?
No, thank you, sir.
Thank you very much.
Thank you, Judge.
Thank you, Ms. Hurt.
Okay.